Good afternoon, everyone. I'm Halley Auger, an employment lawyer out of Calgary, Alberta, working at Samfiru, Tumarkin. Welcome to the live stream. We're here to answer any questions you have. You can put your questions in at LinkedIn, Facebook, YouTube, and I'll provide you with some summary information and advice on your situation. Not sure how busy it's going to be today because we have a beautiful sunny day in Calgary, and hopefully you're not inside worrying about your employment issues, and hopefully you're out enjoying the day. But if you do have employment concerns, please write in. We've got half an hour to answer all your questions. While we're just getting started, there's a topic I wanted to discuss. Some exciting news is coming out with respect to a big corporate merger purchase. It looks like Salesforce is going to be entering negotiations to buy the assets of Informatica in an $8 billion deal. So that can be very, very exciting times for employees, both on the Informatica side and the Salesforce side. It's assumed that Informatica employees will be absorbed by Salesforce. And they will be expanding operations. So there's two things I want to discuss about what can happen. And the first is for employees who are being kept on in the transfer. What happens in a merger or an amalgamation or a purchase in these cases is often employees will transfer their employment. So a record of employment would be issued, ending employment with one employer, Informatica, and then your employment will carry on with Salesforce. Now, if you're in this situation, your employer can do a couple of things. Your current employer, so in this case, Informatica, can terminate your employment, in which case you would be provided with either working notice or pay in lieu of working notice, which we, colloquially refer to as severance. And that amount of notice can be affected by whether you are receiving a job offer to go to Salesforce. If so, the packages, might be quite small, because the whole point of notice or pay in lieu of notice is to cushion an employee while they're actively on the job search for comparable employment. But for many employees, that job search won't take very long because they have an offer of comparable employment on the table from Salesforce. And so they may just receive the statutory minimums under the Employment Standards Code, or in other provinces, the Employment Standards Act. If employees are not being brought on to Salesforce and their employment is coming to an end, perhaps because of redundancies, overlap between employees that do the same tasks, you may get severance packages, and those packages can be up to 24 months pay in lieu of notice. So if you are getting let go from your employment because you're not going to be part of the new company, or you're not moving over to Salesforce, you can contact us. Same with Salesforce employees. Because there are redundancies, we may see employees from Salesforce likewise getting packaged out. So please don't hesitate to reach out and we can review those packages. You can contact us at employmentlawyer.ca. Now, for employees that are being carried over from Informatica to Salesforce, there's another way that your employment can continue. Informatica doesn't have to terminate. Employment can be simply carried on with the name of your employer changes, but everything else stays the same. In that case, you're not getting terminated from Informatica. Your years of service would be recognized, and all benefits and salaries, all pay and terms of employment should remain the same. So that's frequently what we see, particularly in Alberta. We see it a lot with oil and gas companies that buy each other up. They may recognize years of service. One of the things you want to be very careful about if your employer your new employer is recognizing your years of service, is to make sure that when you're moving over to the new company, that they're not sneaking in any terms of the employment agreement that would take away rights that you have. Mostly we're looking at significant changes, decrease in compensation, changes in work hours or benefits, or termination entitlements. So you may have been entitled to common law notice, which could be up to 24 months. And then in your new employment agreement, all of a sudden there's a termination clause that says that you're just limited to the minimums set out in Employment Standards Code legislation. So watch for that. If they're trying to eliminate past service or they're trying to reduce termination entitlements, you may want to speak to an employment lawyer. So please contact us if you'd like us to review those on transition. All right, so turning to some of the questions. Question from Robbie BB. I'm a sales rep. I've operated under the same commission model for a few years. It is being changed, reduced, and only paid out twice annually. Can they make these changes without consulting staff? Great question. We actually see changes in commission plans happen frequently. And this sort of roots into a concept of law called constructive dismissal. That means when an employer is showing that they no longer intend to be bound by the original terms of the employment agreement. Now, your employment agreement that you signed at the outset of your employment may say that they're allowed to make changes. Says they're allowed to make changes to your compensation and you've agreed to that, then you've already consented. So the employer doesn't need to consult with you, as Robbie says, because they've actually already done that. Now, if you don't have an employment agreement that says they can make changes to your compensation, then you're in a question of looking at whether the change to the commission plan will ultimately result in less money to you. And in Alberta, if it's a significant reduction, say 20% pay cut, then that can be a substantial change. And in that case, you can say to your employer, I don't consent. It's a fundamental term of our employment relationship that I get paid a certain amount of money based on certain metrics, and I don't consent to the change. Then the ball is in the employer's court, and the employer can say, all right, well, we're not going to force that change upon you. And then everything just stays the same and you're on the same commission plan. If the employer pushes it and says, nope, this is a company-wide change, we're making the change, take it or leave it, you have the option of treating it as a constructive dismissal. Now, you can assert constructive dismissal if the change is substantial. And we really focus on the overall change in compensation. It sounds like there's some other changes, like being only paid out twice annually. I don't have additional details from Robbie, but that could be that he gets a draw against his commissions, or instead is getting a base salary. It would be bizarre and rare if he's only being paid twice a year, with massive chunks of pay. That would be abnormal. Most pay isn't like that, but if it's now like a commission bonus that's getting paid out twice a year, there still should be, money that you live on month to month. So we're going to focus on the change of overall compensation. So if this change in commission plan has you doing the same work, but for much less pay, that can be a constructive dismissal. So in that case, you can say to your employer, I don't accept the change. Now, be very, very careful. And I do recommend you reach out to speak to one of our lawyers once you get the changed commission plan so that we can assess if the change is a substantial change that would qualify for constructive dismissal. And then we will often provide you with the direct language to use in asserting constructive dismissal. That's because if you say it wrong, you can just be seen as quitting. You can just say, no, thanks, I don't accept the terms, so I quit. It can be very, very hard. I mean, lawyers, like I always say, I'm very good at what I do, but I don't have a magic wand. And so we can't undo it sometimes. So you make sure that you get that in advance. The other thing I'll say about these substantial and significant changes is you have to wave the red flag saying you do not consent. When it comes to constructive dismissal, there's a concept called acquiescence, which means silence is acceptance. So it's not enough for you to go home to your spouse or your friends and say, my employer's changing my compensation. I don't like it. I'm going to look for a new job. And then months later, try and assert constructive dismissal and seek severance. You have to raise the flag right away, right when the change is being implemented. We have a decision out of Alberta that says that the red flag needs to be waved within a couple of weeks. So it's really not a lot of time, because if you are carrying on your employment and you're not saying anything to your employer, that is silence, that's acceptance. So be careful. So Robbie, is it Robbie? Please feel free to reach out to the firm. We can review your compensation plan change, see if you would succeed in a constructive dismissal complaint, and then talk about what would happen if you assert constructive dismissal, what you can expect in terms of a severance package. That can be up to 24 months, depending on your length of service, your age, and some other factors. All right, question on YouTube from Titor. My employer handed me a PIP, that's a performance improvement plan, after being away on a wellness vacation. I've only been back for a short term and have been doing my best to meet expectations. Is it safe for me to sign this document? So, Chator, I know it sounds very scary, and sometimes people do get very nervous about PIPs. That's because people don't talk about being on PIPs. They're actually a lot more common than you'd think. Sometimes employers are using them in good faith. They have an employee who's historically been a great performer, and things are, maybe sliding a bit. Or they have an employee who has a lot of potential. And what a performance improvement plan should do is set out some expectations. Here is the level of performance that we expect you to meet. It should have the specifics. So it should have metrics. It should have precise explanations of what the expectation is. So it sets out the standards. The performance improvement plan should also have an opportunity to improve and meet those expectations. And so sometimes it can't be a turnaround. For example, our last person who wrote in was in sales. And so if there's a change that they want to make in sales, sometimes that can take 6 months to a year to take effect because it's a change of strategy and it will only apply to sales. That sort of happened today, but the effect won't be shown in the numbers for the next 6 months. So how long the performance improvement plan takes is dependent on the circumstances. However, it should be enough time that you can actually meet it. They should also provide some opportunity to provide support to you during that performance improvement plan. So often it will call for meetings with your manager to discuss where you're at and whether there's improvement noticed and what the employer can do to help you meet those targets. Now, I started out my answer by saying some employers use these in good faith. Some employers also use PIPs or performance improvement plans in bad faith. That is when an employer is trying to establish just cause for termination. There is an ability for an employer to allege poor performance rises to the level of irretrievably breaking down the employment relationship and is sort of the type of performance when the employment relationship cannot continue and can terminate for just cause, which means they don't provide any severance. Now, employers may see a long-serving, high-level employee as very expensive to terminate and can do things to try and see if they can fit it into a just cause case. And so sometimes you do, I've been practicing employment law a long time, and so unfortunately I have seen it where employers really bring PIPs in bad faith and they've set unreasonable expectations that nobody could do because there's only, 24 hours in a day, or they're saying, you need to turn around this ship and you only have, 2 weeks to do it. Those are unreasonable expectations. So, if you think that that's happening, certainly reach out. Now, Chitora's question is, can I sign it? You can sign it, and particularly if it's just acknowledging receipt, acknowledging that you've seen it, acknowledging that you've had the conversation. If there are comments that you have on the PIP, particularly if it's not enough time that you think for you to improve the performance or what the targets they want you to meet, you can and should provide that feedback also in writing. So sometimes you have a conversation with your boss over the PIP. Don't hesitate to follow up with an email saying, dear manager, thank you so much for taking the time to chat with me today. I just want to confirm that at the meeting we talked about, extending, or, I mentioned that, I'm unable to meet those targets in the next month, but the month after I think I can do it, or whatever it is. So make sure you're putting your comments in writing on those PIPs. Okay, question on YouTube from Ricardo. My company is closing the warehouse I've been working at for 9 years. I'm a delivery driver and I'm 43 years old. What sort of severance should I expect for them? Well, Ricardo, it depends. It may be that your employer is providing you working notice that your employment is coming to an end because they're closing the warehouse. I know it seems unfair, but when somebody is terminated without cause, and certainly this is a no-fault termination, you're being closed not because of anything you did, but because the warehouse is closing, your employer has the option of providing notice. So, hey, your last day of employment is, 6 months from now, or pay in lieu of notice. It's the employer's choice. So the employer can provide only notice, only pay in lieu of notice, or a combination of both. So it may be that you've received working notice. Now, for it to count as working notice, it should be a formal letter that says you are receiving working notice that your employment is coming to an end at some day in the future. So whether it's, September 1st or whatever. And then that counts as your working notice period. Now, if they're providing you a combination of working notice and pay in lieu of notice, then you need to get the mandatory minimums. I'm assuming that you are a provincially regulated employee. So your company isn't, a big bank. It's not a telecommunications company, and that it's strictly a normal employer. And so if you've been there 9 years, then you get a mandatory minimum of 6 weeks notice or pay in lieu of notice. Now that's Alberta. So 6 weeks for an employee who's been there for more than 8 years, but less than 10 years. Now, the question of whether Ricardo was entitled to something more than just the mandatory minimums depends on an assessment of his age. He says he's 43, length of service, 9 years, character of employment. So he's a delivery driver, which is a transferable skill set, non-managerial. I don't know the level of compensation, could be in line with fair market value. And then the last factor is availability of comparable jobs in the marketplace. And that's going to be where Ricardo's entitlement is maybe short, because as a delivery driver, there's a lot of availability of comparable jobs in the marketplace. And so if it really is the case that Ricardo can find a new job within 6 weeks that pays just as well as his current employment, he may only be entitled to 6 weeks pay. Now, if there's any additional factors that may go into it, if he's very highly paid, or he's part of a pension, or we have a disability or some bad faith to consider, those types of things can increase the notice period. One of the other things that can increase the notice period is if they shut down a warehouse and there's 50 delivery drivers, all of a sudden there's 50 delivery drivers who are applying for the same job. And so when we talk about availability of comparable jobs in the marketplace, it's not that Ricardo isn't qualified for all of those jobs. It's just that the competition is stiff because, there's 20 jobs posted and there's 50 applicants, all of which Ricardo knows are, capable of doing the same job because he worked with them. So that can also affect the notice period. So Ricardo, if you're getting a termination package and you want a lawyer to review it, that's what we do all day, every day. I did 3 of them this morning, reviewing severance packages. Please feel free to reach out to our firm. We can provide you with some tailored advice on how to assess your notice period. Okay, employmentlawyer.ca. All right, Vicky, I am a financial planner under a senior planner. He is selling his book and retiring at the end of the summer. He's been vague about my position. If he doesn't pass it down to me, am I owed anything? Well, yes. I mean, if he is shutting down the business, kind of like Ricardo's situation, you're entitled to either working notice that your employment is coming to an end, or pay in lieu of working notice. And financial planner, again, we need to know your age, your length of service, a little bit more about what you do, and talk about how long you think it might take you to find a job, and we can assess a severance package for you. Now, unless you have a contract between you and the senior planner, or even if you work for one of the big shops and there's a policy that talks about transitioning a book of business, you could have a contractual entitlement to that book of business. You'd really want a lawyer assessing the specific facts of your case to see if there's any contractual entitlement, because there is no default entitlement or common law entitlement to be passed down someone's book of business. The fact that he's being vague about your position, I'd probably try and see what you can get nailed down. I know it's a tough conversation. People don't, when they don't like to think about their retirement because they don't know what exactly their plans, but their decisions affect their employees and their juniors who are working with them or under them. So really try and see if you can get some of that information nailed down, okay? All right, Vicky followed up. Is there any obligation on his end to consider me for selling his book? I'm not aware of any common law or default position that he would have to consider you for that book of business. As a lawyer, we often deal in legal obligations. Now, are there moral or ethical obligations? Probably. But whether there's a legal obligation probably arises from any contracts you have itself. So I'd take a look at that. I do want to add one thing, Vicki, because when I talk about contracts, contracts can be in writing, but contracts can also be oral. And so if there have been representations made to you that, hey, work here, I'll teach you everything I know, and when I retire, I'm going to hand you my book of business, you're allowed to rely on those representations. Maybe in reliance of those representations, you haven't taken another position elsewhere, or you haven't, accepted a job offer for more money or, closer to home. And you really took this position in reliance of that opportunity. So there may be additional circumstances that you might want to talk about with a lawyer who can really dig in to your matter to see if there's any verbal or written contracts that apply, as well as any representations that may have been made to you that you can then rely on. Okay, question from Johan. Are there any circumstances where an employee would get more than 24 months? I'm a 28-year employee and our company announced a shutdown, but I'm 3 years from retirement. There are surprisingly some decisions. I've been practicing law for 10 or 11 years, and I've always been told that there's this rough upper limit of 24-month severance, but we actually did see longer notice periods than that in recent years. There are things that can extend the notice period. During COVID, we saw the COVID bump. And so that could extend notice periods. We also have seen people who had disabilities that extended the notice period. We've seen people who were 2.5 years from retirement, and so the court has extended by a little bit. The problem, Johan, is that even though you may have a planned retirement date of 3 years out, unless there's something that you can show that your employer sort of promised you employment until retirement, that can be a little hard to rely on. You'd still be under an obligation to try and look for new work after you've been terminated. So severance isn't paid to you for the fact of your termination. Severance is paid to you in an amount that represents what the amount of money you would have earned had you received working notice. And so in that concept, when you're terminated through no fault of your own, the court still imposes an obligation on you to go out and reduce the losses that you've suffered by the loss of your job. And the way you do that is by looking for new work. It's called the duty to mitigate. Duty is the legal term for obligation. Mitigate means reduce losses. So in the post-termination period of time, you'd be under an obligation to look for new work and provide evidence that you're looking for new work, keeping a list of all the places you've applied to, copies of the job postings, copies of your application materials, and any communications with potential employers. And then if you do find new work and the offer is comparable, the court says, well, you're under an obligation to accept it. And even if you don't accept it, because perhaps maybe you do just want to retire early, it can still be considered a failure to mitigate, meaning it can reduce the period of time you're entitled to. So, Johan, the answer is yes, there are circumstances in which the courts have awarded more than 24 months pay in lieu of notice. We've seen it. Our firm has actually seen it. So you should reach out because there can be additional factors. And one of the factors we haven't talked about is whether you are a part of a private pension. So not CPP, but LAP, the local area pension plan or something like that. So we can talk about some of those things. The other thing an employment lawyer can do for you, Johan, is talk about structuring those packages. Lawyers do have a bag of tricks on how to maximize tax efficiencies so that you can sort of stretch out 24 months severance to make it the equivalent post-tax of 28 months income. So don't hesitate to reach out, employmentlawyer.ca. It was lovely talking to everyone today. Our Calgary office will be back next week with Luke Serta on June 2nd. It was great to see you guys and great questions today. It was a delight to hear from you all.